Yes, please.
Item number 1, pronouncement of judgment.
It is a constitutional principle of high value and vintage that the high prerogative power of the High Court to issue writs is not intended to be taken away by any provision of the Constitution unless such exclusionary provision is expressly made. Article 212 of the Constitution presupposes legal and regular proceedings in the legislature. If that be the case, then the procedure in conducting the proceeding by the Speaker cannot be questioned in any court of law. This is for the reason that the legislature, under the doctrine of separation of powers, is given the autonomy to conduct its own proceedings. If the proceedings are unconstitutional or illegal or wholly beyond the competence of the legislature, then the legislature steps out of the protection of Article 212, and the High Court, in the exercise of its writ jurisdiction, has the power to adjudge null and void the proceedings as well as all the illegal procedures followed to implement it. Now, if the case here was that a valid motion was not being tabled by the Speaker, then in that case the Speaker was acting unconstitutionally and dehoused the jurisdiction and power conferred on him. The court would have jurisdiction to declare the act as unconstitutional and direct him to place the motion before the House. In this case, the motion is premature, as the audit report under the rules of procedure and conduct of business in the Meghalaya Legislative Assembly has to be placed before the Committee of Public Accounts for its examination under Rule 241 of the Rules of Procedure and Conduct of Business of the Meghalaya Legislative Assembly. It is empowered to do so under Article 151, bracket 2 of the Constitution, which says that the report of the Comptroller and Auditor General of India relating to the accounts of the state shall be submitted to the Governor, who shall cause them to be laid before the legislature of the state. It is to be read with Article 208 of the Constitution, vesting power in the legislature to make rules for regulating its procedure and conduct of its business. Hence, there is nothing unconstitutional or illegal in the functioning of the Speaker, which would invite interference by the court. Article 212 comes in the way of the court adjudging the merits of the procedure followed by it. Once the auditor's report is examined by the Public Accounts Committee, it would certainly give a fresh cause of action to the appellant to present a new special motion if he is so advised. With the above observations, we affirm the impugned judgment and order and dispose of the appeal accordingly.
Grateful.
Item number 2,
Yes, please.
Lordship, I'm appearing on behalf of the state, my lord. The state is yet to receive any communication or documents, my lord, with regard to the instant suo moto matter.
Whose application is this?
It's a suo moto matter, lordship. This, concerning wetlands lordship as per the directions of the Honorable Supreme Court.
Please take note. The learned Registrar General of this court had placed a note dated 6 February 2025, comma, before the Chief Justice in his administrative capacity. Full stop. Next line. In that note, he had drawn the attention of the Chief Justice to an order dated 11 December 2024 made by the Supreme Court in writ petition bracket C number 304 of 2018, Anand Arya versus Union of India, with connected matters. Together with an affidavit of the Ministry of Environment, Forest and Climate Change, bracket MOEF and CC, bracket closed, filed in an earlier writ petition, comma, writ petition bracket civil, bracket closed, number 230 of 2001, M.K. Balakrishnan and others versus Union of India and others. In the said order of the Supreme Court, paragraph, the High Courts, comma, including this court, were requested to treat the said affidavit as a from two quotation, to treat the affidavit as a suo motu public interest litigation where an amicus be appointed, comma, if necessary, to assist the court to ensure that the Ramsar, RAMSAR capital sites within their jurisdiction are properly maintained. You get the quotation from the last paragraph of this order. pink flag. Paragraph, in other words, the wetlands situated, the wetland, if any, wetlands, if any, situated in the state have to be identified. Maintained and preserved as they were considered to be of great heritage value with international importance. Paragraph. By the administrative order of the Chief Justice dated 6th February 2025, the Wetlands Authority of this state was asked to furnish a report. Paragraph. The Learned Registrar General on 24th February 2025 placed another note stating that the Secretary Meghalaya of State Wetland Authority, Shillong, by their letter dated 14th February 2025, informed him that there were no notified Ramsar site in this state. Paragraph. On receipt of this note from the Learned Registrar General, the Chief Justice directed a public interest litigation to be started suo motu by the Registrar General to seek confirmation of the above assertion of the Wetland Authority and for other directions in compliance with the said order of the Supreme Court. Therefore, let a public interest litigation be registered on the basis of the said affidavit of the central government in petition bracket civil (230) of 2001 M.K. Balakrishnan and others versus Union of India and others. Paragraph. The Registrar General is directed to serve copies of the papers on the State Learned Advocate General Learned Deputy Solicitor General of India, the Wetlands Authority, Member Secretary, Meghalaya State Wetland Authority, Shillong. The Chief Conservator of Forests, bracket Administration, Department of Forests and Environment, Government of Meghalaya. By 10th March, list this application once again on 12th March.
Much obliged, Lordship.
Item number 3.
May it please, Your Lordship. Lordship, I'm seeking for accommodation, Your Lordship, in this matter. Senior Counsel is on sanction leave, Your Lordship.
Whose appeal is this?
So, Your Lordship, there are two matters connected, item 3 and 4. In item 3, I am the appellant and he is the respondent.
And the next, I'm for the petitioner, Your Lordship.
Yes, in item 3, Your Lordship, there are two writ appeal connected. In one of the appeal, that is WA 24, I am for the appellant and Mr. Pal is for respondent. And another writ appeal 2 of 25, Mr. Pal is the appellant and I am the respondent.
And item number 4?
Item number 4 is not related to the. That's different matter.
When do you want to do the matter?
Lordship, after 3 weeks, Your Lordship.
When do you want?
After 3 weeks, Your Lordship.
Why such long adjournments?
Lordship, Senior Counsel is on bereavement, Your Lordship. He's on bereavement, Your Lordship.
Who is your senior counsel?
Mr. Paul, Your Lordship.
What do you say?
Lordship, I am told is that Shraddha of his mother is on 13th March because after 30 days they are doing.
Considering the prayer for adjournment made on the ground of the bereavement of Mr. Paul, learned senior advocate appearing for one of the parties, by consent of learned counsel for the parties, these appeals are adjourned till 19th March, paragraph. We make it clear that on that day no further adjournment prayer will be entertained.
Item number 4.
May it please, Your Lordship.
Yes. Yes.
Yes, ma'am. The electricity distribution company is before your lordship challenging the order of a learned single judge, my lord. The facts in brief are, my lord, that the distribution company raised a demand, raised a bill on respondent number 3 and 4 for payment of electricity dues, my lord, outstanding electricity dues, my lord. That your lordship will find at page 109. Those bills were raised on two companies, my lord. Name is Summit Digital Infrastructure Limited and Reliance Jio Infocom. Reliance Jio Infocom is respondent number 3 and Summit Digital Infrastructure is respondent number 4, my lord. The demand was challenged. My lord, this demand at page 109, that is by notice dated 12th June 23, my lord. This demand was challenged by the petitioner, who is successful, in whose favor resolution plan has been passed by the NCLT Mumbai, my lord.
Yes.
Stating that they are my affiliates and they are covered by waterfall mechanism under IBC code, and therefore this demand is not liable to be paid. The demand was, my lord, the outstanding bill was raised on respondent number 3 and 4. Respondent number petitioner comes before the writ court, says that the payment should not have been raised on 3 and 4 because they are my affiliate and resolution plan has been approved by NCLT. So all dues are covered so far as affiliate are concerned, my lord. That's their case, my lord. My case is, my lord, kindly see. My case is, my lord, kindly see page 109 of the paper book.
Give the paper book. This one. Can we have a look at the impugned judgment and all?
Yes, my lord. Your lordship, kindly see the impugned judgment, page 40. And at page 40, my lord, my arguments have been recorded.
1-4.
40, my lord. 40. Para 7, lordship may kindly see para 2 first, my lord. Respondent number 2, Meghalaya Power Distribution Company Limited, paragraph 2 at page 41, my lord. While later dated 12th June 23, sought recovery of electricity dues from the petitioner for the periods prior to takeover under the Insolvency Code and from the affiliates of petitioner number 1, respondent number 3 and 4. Your lordship may kindly mark that recovery is being sought from respondent number 3 and 4 by threatening to disconnect the existing electricity connection for the mobile towers and further refuse to provide new electricity connection to the petitioner and its affiliate. Aggrieved thereby, the writ petitioner by way of instant writ petition have therefore put the challenge to the impugned letter and demand dated 12th June 23 issued by respondent number 2 to the extent that it pertains to dues of petitioner number 1 prior to 22nd December 2022, my lord. My submissions, my lord, their case is that it is covered by the successful resolution plan in favor of the petitioner, my lord. My submissions have been recorded by learned single judge at page 45, paragraph 7, my lord. Page 45, paragraph 7, my lord. Has raised the following grounds. First, that a resolution plan ignores the statutory dues is invalid and not binding. Secondly, resolution plan does not provide for waiver of statutory dues. Thirdly, electricity dues are statutory in nature and the liabilities does not cease. Fourthly, the writ petition is not maintainable due to the presence of effective alternative remedy. And fifth, and is based on disputed question fact, as orders under challenge are against the performer respond number 3 and 4, my lord. So my case was also that the orders have not been challenged by respond number 3 and 4, my lord.
Yes.
And therefore the petitioner cannot come and challenge their demand on their behalf on the ground that they are affiliate, my lord. This was my submission, my lord. This particular submission, my lord, you also will find the reference of that submission again at page 49, my lord. Paragraph 11 paragraph 11 at page 48. The arguments have also been advanced that the writ is not maintainable. There exists disputed question of fact in as much as the order under challenge, against the performance number 3 and 4, it is submitted petitioner has sought passing of recovery notice to performance point 3 and 4, and these respondents themselves have not approached this court to assail the same, meaning thereby they are not agreed, which would make the instant petition on behalf of respondent 3 and 4 not maintainable in law. This was my specific submission before the learned single judge, my lord. And this has not been dealt by the learned single judge. This has not been adverted to my, you also will see it has been further submitted that disputed question of fact that petitioner has not quantified the amount payable by respondent 3 before the alleged cut-off date. It is also further submitted there is no clarity as to the inter-se relation between the noticee respondent 3 and petitioner, which makes the writ petition vague and not maintainable. On the point of this, learned relied on these judgments, my lord. Now, in paragraph 13, my lord,
What is the alternative remedy?
alternative remedy is that dispute arising out of the successful resolution plan will have to go before the NCLT or adjudicating authority under section 60, section 65 of Insolvency and Bankruptcy Code, my lord. Section 60, subsection 5 of section 60, my lord, and under regulations, my lord, which is called Insolvency and Bankruptcy Board of India Regulation 2016, which is and the Regulation 39.8 and 39.9. These section 60, subsection 5, my lord, and 39.8 because the prayer of the petitioner.
60 or 16?
60,
Subsection 5 of the bankruptcy code.
yes, my lord. IBC code, my lord, and regulation 39.8 and 39.9 Insolvency and Bankruptcy Board Regulations 2016. Because, my lord, the learned single judge has dealt that aspect, my lord. If your lordship kindly see the last paragraph of the judgment, my lord, where this particular submission has been dealt at page 58, paragraph 19, my lord, of the impugned judgment and order, my lord.
Dealt with in page?
Page 58, paragraph 19. On the other challenge, paragraph 19 at page 58, at the top of the page, Milord. On the other challenge, the writ petition is not maintainable due to availability of alternative efficacious remedy by virtue of section 60 within bracket 5 within bracket C of INB Code 2016. This argument is not accepted as the writ court is clearly seeking a mandamus in view of the action of respondent number 1 and 2, where in spite of binding nature of section 31 of INB Code, are denying the writ petition electricity connection by making the same contingent upon recovery of pending dues not attributable to it. Judgment referred to by the learned on different footing and of no assistance are not discussed here. My first ground was, Milord, that the recovery notices have been issued to respondent number 3 and 4.
Yes.
There is no resolution plan in their favor. They have not filed the writ petition challenging those recovery notices.
Who are 3 and 4?
3 and 4 are Summit Digital Infrastructure,
Body corporate.
And Reliance Jio Infocom Limited, Milord. They are not before the Honorable High Court challenging the demand notice. They are independent body corporate, independent juristic person. And if I can show, Milord, two pages, Milord, 109, the recovery notice, and their prayer, Milord, in the writ petition. Which is this is 12th June 2023. This is the outstanding electricity dues notice to Summit and subsidiary of Reliance Jio, Milord. Your Lordship will find at the top of the page Summit Digital Infrastructure Private Limited, Milord. And the outstanding electricity dues against mobile towers payment dues thereof. With reference to the subject cited above, I am to bring to your kind notice that there are 116 mobile towers having power supply with outstanding electricity dues of 5,000 only, each and totaling amount to rupees 70,68,000, 64,000. As on 31st
So
May.
here the notice is respondent number
3, the Summit is, Milord, Summit is respondent number 4, and subsidiary Reliance Jio is respondent number 3 in the main writ petition, Milord. And your Lordship kindly see the prayer in the writ petition, Milord. At page 106, Milord, the prayer. (106), Milord. In the premise aforesaid, it is prayed that your Lordship may be pleased to A. Issue a writ in the nature of mandamus to respondent number 2 to abide by the provisions of section 31(1) of Insolvency Code. B. Declare that an approved resolution plan dated 25th November 2019 is binding and petitioners are not liable to pay any debt claims and dues prior to 22nd December 2012 to respond number 2, quash and set aside the impugned demand notice dated 12th June 2023 to the extent that it pertains to dues of petition number 1 prior to 22nd December 22, direct the respondent number 2 not to take any coercive action against the petitioner and its affiliate, including respondent number 3 and 4, for recovery of any perpetrated dues of petition number 1. So a bare reading of the prayer, my lord, shows that what is under challenge is the demand notice dated 12th June 2023. And those,
That
the
is at
demand
page-
notice,
That is at page 109.
109, my lord. And both entities, my lord, Summit Digital Infrastructure Private Limited and Reliance Jio Infocom, my lord, are private entities, my lord. And kindly see the memo parties, my lord, where they have been made.
But first show us the provision in the code,
IBC code regarding alternative.
whether it covers subsidiaries or group companies, etc. Let us have a look.
It's not their case also, they have not pleaded that it covers subsidiaries also, because these are all independent legal juristic entities. I can show.
But how have they then implemented the respondent number?
Yes, your lordship, kindly see one paragraph in the one paragraph in the writ petition, my lord. Paragraph 5, my lord,
Page.
page 76. Paragraph 5, my lord. Despite the settled position of law, page 76, paragraph 5. Respondent number 2, Meghalaya Power Distribution Corporation Limited, has addressed a letter of 12th June 23, threatening to undertake coercive action against the petitioner to recover the purported electricity dues of petitioner for period prior to takeover of the petitioner under the Insolvency Code of on 22nd December 2022. Respondent number 2 is also seeking to recover the purported dues from affiliate of petitioner, that is respondent number 3 and 4, threatening to disconnect the existing electricity connections for the mobile towers and is refusing to provide any new electricity connection to the petitioner and its affiliates until petitioner's purported dues has been cleared. Demand notice dated and coercive action listed are together the impugned action, my lord. So the entire pleading is that they are my affiliates and therefore they are covered by the resolution plan in favor of the petitioner. And my lord, this particular kindly see page 762, where I have rebutted this aspect in my counter affidavit, my lord. Paragraph 13. 762, sir.
Page.
Page 762, my lord. The counter affidavit starts, my lord, from page 758 and 762, my lord, paragraph 13. Paragraph 13, my lord.
Yes.
That it is submitted that petitioner has sought quashing of the recovery notice to perform respondent number 3 and 4, and it is not in dispute that noticee respondent number 3 and 4 have not approached this honorable court against the notice issued by respondent number 2, the respondent number 3 and 4. In view of the above, petition is also not maintainable by party to whom the notice has not by a party to whom the notice has not been issued. Respondent number 3 and 4 are not agreed, therefore petition on behalf of Reliance Infratel are not maintainable in law. 14 minutes. A bare proposal of writ petition shows that involves disputed question of fact inasmuch as petitioner has not quantified how much amount is payable by respondent number 3 and 4 before the alleged court of date. It is humbly submitted that writ court may not venture into the commercial details as it requires examination of claim and counterclaim of party before the honorable court. In 15, it is submitted that there is no clarity to inter se relation between noticee, respondent number 3 and petitioner. The petitioner is vague and is liable to be dismissed on this ground. It is also submitted that petitioner has stated that respondent number 3 and 4 are affiliate of petitioner without disclosing any material. Moreover, the respondent number 3 and 4 are independent juristic person and are capable of suing on being sued. Therefore, claims of respondent 2 against 3 and 4 cannot be agitated by petitioner company and is an independent juristic person. There is no cause of action in favor of the petitioner. 16. It is submitted that the relief sought for Reliance Jio Infocom Limited and Summit Digital Infrastructure Limited are in no way connected to petitioner number 1. Reliance Infratel Limited is submitted that petitioner 1 was taken over by Reliance.
Provision in the Mr. Advocate General, the banking code,
Yes,
which gives this protection. We just want to see whether it protects affiliates, subsidiaries, etc.
Yes, my
What is the extent of the protection?
Yeah, my lord,
Can I assist for a minute?
Yes, yes.
My lord, why we have filed it and not the respondent 3 and 4 is for the limited purpose. Lord, we are the successful resolution applicant who acquired the corporate data through an IBC process. These are the dues of the corporate data originally. On acquisition, my lord, a resolution through a process of a resolution plan, it gets finalized and all these liabilities have been extinguished. When my turn comes, I'll explain it. So, a liability of this dues is against me, the writ petitioner, originally. Instead of, it gets extinguished through the proper process of law. Knowing fully well that they can't recover it from me, they go to respondent 3 and 4, my subsidiaries, and recover what? Recover the same dues which are due to me from them. But if it is their electricity dues, I can't file a writ petition. It is my dues which they are trying to collect it indirectly from these two entities who are my subsidiaries, who are my affiliates. So, my lord,
The consumption of electricity was made by you.
by my corporate data, whom I have acquired, I am now the SRA.
I see.
Therefore, the liability is my liability which stands extinguished through this plan, approved by the quasi-judicial body, the adjudicating authority, NCLT, it has attained finality. Confirmed by Supreme Court. So, when my turn comes, so we have a cause of action to certainly plead. Respondent 3 and 4, they should not have gone at all. That's our case, which I'll demonstrate when I come. That's the only point. Deeply obliged. Sorry for the
So, Mr. Advocate General, how much time you are likely to take?
it will take some time, my lord, because I have some judgments to rely upon, my lord, in support of, because I have got 4 contentions. One, my lord, that the petitioner is not aggrieved person against respondent number 3 and 4, my lord. That is one. Second, under the successful plan also, statutory obligations have not been waived in the successful plan. Third, I rely on 2 judgments of the Honorable Supreme Court, my lord, rendered on this point, my lord. And so this will take some time, at least half an hour.
Because today we have to rise and tomorrow we are not sitting.
Yes, my lord.
So, we are sorry for the inconvenience caused, but Learned Additional Solicitor General, if you can choose any 2 days where we will take up only your matter, not any other matter.
May I only make one request, because you're not, but I never, this is because union is not involved, I've come, and I don't even take matters against state. This is my personal friend, my classmate, who is the legal head, therefore out of compulsion, I'm taking this matter.
No,
Virtually, can I
it will be a pleasure to be assisted by you, certainly virtually if you like.
Virtually, that's then not a problem. Please, my lord, whatever is convenient.
It is, your lordship may have it after 2 weeks, after 18.
No, it is, if it is a little closer to that, it will be better.
Yes, my lord.
Can we check up the dates with both of us and blood
Yes.
give it to your lordship's court?
Would it be next week then the Continuation is there.
Next week, in first, my lord, next week I am in slightly difficult position. From March, my lord, 3rd to 7th, I am held up. Before that, I can do it, my lord, and or after that also I can do it, my lord.
After 7th month.
7th March, my lord.
Then there is that holy break.
With the 10th, we are working, 11th, 10th, 11th, 12th.
All right, please choose 2 days.
Whatever is convenient to learned ASG, we will.
Check up the.
What is going to be convenient date for you?
Matters will be fixed every day, madam. You have to choose days where there are no partnered matters. Just lay matters, legacy matters have been specially fixed. Those days. Matters will be there. You will hardly have a blank list. It's 90-20 is way too way. Anyway, we will do online, so there is no problem. Yes. Yes.
Well, AG can complete it on 13th if it's convenient, and I'll reply on 17th. Because 3 days of holidays, never mind, we'll complete it.
All right.
And I may be permitted virtual if it
Yes, yes.
It may extremely
Yes. No.
pleasure to address
Please,
this.
please take down. Learned Advocate General commences his arguments. For the appellant, that Meghalaya commences his argument, but does not conclude the same. Learned Additional Solicitor General also makes some preliminary
Your Lordship may make it as L. Venkataraman Senior Advocate, because this is in a senior advocate's capacity I'm appearing, because it's a private party.
That is all right, but then if you have the permission to appear
Yes,
for
but
private,
Lordship will put it as L. Venkataraman Senior Advocate for this brief, not as ASG.
Learned Senior Advocate, appearing for the respondent, also makes some preliminary submissions. Paragraph. List. There are 2 appeals.
Only one thing.
Okay. List this appeal for further arguments on 13th March and 17th March.
Yes.
At the top of the list,
Grateful, Lord.
paragraph. Learned so-and-so senior advocate is given leave to appear virtually.
Extremely obliged. Deeply obliged.
This should be